Okay, this next section we're going to look at is negotiable instruments. Negotiable instruments are also referred to as commercial paper, and this is the second topic in Module 1. Specifically, we'll look at 11 problems. Problem 1 deals with the nature of negotiable instruments, and that falls under UCC, which again is the Uniform Commercial Code, Article 3. And the article has 4 specific types of negotiable instruments: drafts, checks, promissory notes, and certificates of deposit. So if we look at question 1, it's asking which of the following instruments is subject to the provisions of the negotiable instruments article of the UCC, and the only one here that matches is item C. So A, B, and D are incorrect, and a certificate of deposit is the correct answer. Okay, problem number 3 deals with the requirements of negotiability, and there are 5 requirements. It must be in writing and signed by the maker or the drawer. It must contain an unconditional promise or order to pay a fixed amount of money. It must be payable on demand or at a definite time, be payable to order or to bearer, and not state any other undertaking or instruction. Problem number 3 talks about if an instrument does not meet one of the requirements of negotiability, which of these will still apply. So if a required element of the 5 elements of negotiability is not present, then certain special protections provided by the law are not available. However, the contract right embodied in the non-negotiable instrument will usually be transferable because most contract rights, especially the right to receive money, are assignable. But the assignee will take no better right than that held by his or her assignor. So if we look at the 4 options, answer B is incorrect because a contract right may have value even if not evidenced by a negotiable instrument. Answer C is incorrect because contract rights are generally assignable, as we just stated. And answer D is incorrect. A transferee of a non-negotiable instrument takes subject to all defenses of the obligor. So therefore the correct answer is A, that even if it doesn't meet one of the requirements of negotiability, the rights contained therein will still be transferable. Problem 6 deals with the types of negotiable instruments and the parties thereto. So Gold is holding the following instruments. You have to take a look at it. And the question is, what type of instrument is it? And if we look at answer A, it's incorrect because this instrument is payable on April 9th, year 1. Thus it is not post-dated because it's payable before its issue date of April 15th, year 1. Answer B is incorrect because a promissory note is a 2-party instrument in which one person promises to pay another person. And in this case, we have 3 parties. We have the Sussex National Bank. We pay to the order of Tom Gold, and it's signed by Lester Davis, so it can't be a promissory note. Answer D is incorrect because the draft is payable on April 9th, year 1, but not on demand. Therefore, they can't actually get payment for it until April 9th. And remember, one of the requirements is that it's payable on demand. Or at sight, otherwise indicates that it's payable at the will of the holder. And it states no time for payment. This draft is payable at a definite time because it is payable at a fixed date. So as it says in the problem, this is a draft because it's a 3-party instrument in which one person, the drawer, orders a second person, the drawee, to pay a third person, the payee. Therefore, the correct answer is C. This is a draft. Okay, problem 9 deals with negotiability, and specifically UCC Article 3, Section 401 talks about how a signature may be made. And the requirements are manually or by means of a device or machine, such as if you're using a computer, and by the use of any name, including a trade or assumed name, or by a word, mark, or symbol executed or adopted by a person with present intention to authenticate a writing. So if we look at the question, it says to be negotiable, an instrument must be written and signed, so which of the following is true? So answer A is incorrect because it says a drawee's signature is required for the negotiability of a draft. Only the drawer's signature is required. Answer C is incorrect because the signature may be stamped, printed, typed, or produced by some other mechanical method. If you remember when you go on the computer and you buy something and it goes down and asks you to enter your name or enter your initials, and that's an electronic signature, which is now acceptable in all jurisdictions in the United States. So the signature does not have to be handwritten. And answer D, a signature must be placed at the end of the instrument, is also incorrect, because the signature may appear almost anywhere, but placement at the end is usual and makes it clear who issued the instrument. So even though that's the practice, we generally see that the signature is at the bottom of the instrument, even if we're looking at it electronically on the computer. However, it's not required to be. So answer B is correct. A signature may be any symbol intended by a party to authenticate a writing. Problem 14 deals with the negotiability of the instrument. UCC Article 3, Section 104 says an instrument is non-negotiable if it is not payable to order or bearer when it was first issued or came into the possession of a holder. So in this case, the following instrument is in the possession of Bill North, and it states, on May 30, year 1, I promise to pay Bill North, the bearer of this document, $1,800. It's signed by Joseph Peppers, and it references at the bottom an auto purchase contract. And the question is, this instrument is, and answer A is incorrect because an issue date is not necessary for negotiability. Because even though it doesn't have a date as to when it was created, it does have a payable date. Answer C is incorrect because an instrument is non-negotiable if it is not payable to order or to bearer. Reference to a separate agreement would impair negotiability only if the obligation were made subject to the other agreement. And in this case, it's not subject. It just references at the bottom the auto purchase contract. And answer D is incorrect because more is required for negotiability than that an instrument be payable at a definite time or on demand. You notice that this one says that it's payable on May 30th, year 1. So therefore, answer B is correct because it's non-negotiable because it is not payable to order or bearer. It is payable to a specific person, Bill North, and as it says here, it's non-negotiable if it is not payable to order or bearer when it was first issued or came into the possession of a holder. So in this case, it was payable to Bill North and it's held by Bill North. Therefore, it's non-negotiable for those reasons. Problem 17 deals with negotiability in the statement that describes the instrument. So an instrument reads as follows: $10,000, Ludlow, Vermont, February 1, year 1. I promise to pay to the order of Custer Corp. $10,000 within 10 days after the sale of my 2-carat diamond ring. I have pledged the sale proceeds to secure my obligation thereunder. And it's signed by R. Harris. The question is asking which of the following statements correctly describes the above instrument. So first we must look at the requirements of negotiability. It must be in writing, we're talking about the instrument, and signed by the maker or drawer. It must contain an unconditional promise or order to pay a fixed amount of money, be payable on demand or at a definite time, be payable to order or to bearer, and not state any other undertaking or instruction. So if we look at answer B, it says the instrument is non-negotiable because it is secured by the proceeds of the sale of the ring. But that's incorrect because the existence of security does not condition the obligation to pay or affect the note's negotiability. Answer C says the instrument is a negotiable promissory note. And that is incorrect because the promise is conditioned upon the sale of the ring. And answer D, the instrument is a negotiable side draft payable on demand. In a draft, the drawer orders the drawee to pay a third person, and in this case there are only two parties involved, Custer Corp and R. Harris. So therefore, when we look at answer A, the reason is correct because the instrument is a signed writing promising to pay a fixed amount of money to the order of an identified person. A fixed amount of money means it is possible to compute the amount from the face of the instrument. It lists $10,000, but the obligation to pay and its timing depend on an uncertain event, the sale of the ring. So as you notice in bold, I put be payable on demand or at a definite time. It doesn't meet that requirement because it's only payable once the sale of the ring has occurred, and he has to pay it within 10 days. So you can't demand the payment until after the ring has sold, and there's not a fixed, specific, or what we call a definite time to pay it. So therefore, answer A is correct. The instrument is non-negotiable because it is not payable at a definite time. Problem 19 deals with negotiation and endorsements and the proper means of negotiating a bearer instrument. When we talk about endorsements, we're talking about a signature or a mark. It could be words that indicates what you want to do with the instrument. For example, when you have a check and it's written to you and you want to cash it, and it's written to your name or my name, Cynthia Orms, if I turn the check over and I write sign Cynthia Orms on the back, and I take it to a bank it is either drawn upon or a bank in which I have an account, I have endorsed that, therefore they can issue the cash from that check to me. Another way to endorse, for example, a check is if you want to deposit it. You don't have to sign your name, but you can put deposit only and your account number, or deposit only and attach a deposit slip with it. And that's another type of endorsement. So UCC Article 3, Section 201 states that negotiation is the voluntary or involuntary transfer of possession of an instrument other than by the issuer to a holder. Okay, so again, person A wrote the check to me, Cynthia Orms. Person A is the issuer. I'm the holder of it, so that would be my voluntary transfer of possession of an instrument to the bank when I endorse it. But specifically in this question, it's asking to negotiate an instrument payable to bearer, one must. So bearer is the person who's holding the instrument, who has possession of the instrument. Answer A talks about transfer possession of and endorse the instrument. That's incorrect because it states the method of negotiating an instrument payable to an identified person. And specifically, this is talking about bearer paper, so anybody who holds possession of it. Answer C is incorrect. It talks about endorsing the instrument because negotiation requires transfer of possession. And remember, the question is asking us to negotiate an instrument payable to bearer, one must. And answer D is incorrect because it says endorse and transfer possession of the instrument with consideration. Remember, consideration, if you remember your contract days from 3135, consideration is you've given something in value back to the holder. And consideration is not required for negotiation. So therefore B, which says transfer possession of the instrument, is correct. If the instrument is payable to an identified person, it is negotiated by transfer of possession and endorsement by the holder. If the instrument is payable to bearer, it is negotiated by transfer of possession alone. And in this case, it specifically states an instrument payable to bearer. Okay, problem 24 deals with negotiation and endorsements. Specifically, the rule states that a restrictive endorsement attempts to limit or prohibit further negotiation or transfer, but it actually cannot prevent further negotiation or transfer. So in this case, the following endorsements appear on the back of the negotiable promissory note payable to Lake Company. Again, this is the back of it. It says pay to John Smith only, Frank Parker, President of Lake Company, signed by John Smith, paid to the order of Sharp Inc., but only if Sharp delivers computers purchased by Mary Harris by March 15th, year 1. Mary Harris. So this is a poor practice to begin with. You're basically writing a contract on the back of an instrument, a promissory note. And so it's asking you which of the following statements is true. So answer A says the note became non-negotiable as a result of Parker's endorsement. And he's the one that signed under the pay to John Smith only. That's incorrect because restrictive endorsements are generally ineffective to limit negotiability. Answer B is incorrect, and it states Harris's conditional endorsement caused the note to be non-negotiable. Now Harris put an additional statement under John Smith's signature and signed it, and that is incorrect because a conditional endorsement does not hinder negotiability. And then answer C states Smith's endorsement effectively prevented further negotiation of the note. And remember, John Smith's signature was underneath the section that said to pay to John Smith only, Frank Parker, President of Lake Company. So his signature came second. And it's incorrect because Smith's endorsement converted negotiable order paper to negotiable bearer paper. So therefore, answer D is correct. Harris's signature was not required to effectively negotiate the note to Sharp. And the reason for that is if it's payable to John Smith and then John Smith signs it, it's now payable to anyone who bears the paper, who has possession of it. So if John Smith gave it to Mary Harris, that person would be able to do whatever they wanted with the promissory note. And it's just like if you have a check, and you probably were told this when you were young and just starting out, that once you sign the back of the check, if you lose that check, anybody who presents that check to be paid can get paid on it. They are a little bit more restrictive now in that it either has to be the bank in which it was drawn on, or the bank of the person who holds the account. But there are people who actually pay checks in which they're not supposed to, but that's against the rules. So again, remember, if there's an endorsement on the back that aligns with who it is written to on the front or who it is presented to on the front, then that endorsement allows anyone who bears it after that fact to take that instrument in whatever means it's offering, whether it's a promissory note, whether it's a check for $1,000. Okay, problem 30 is dealing with the concept of a holder in due course as opposed to just a holder. And the definition is that a holder in due course is a holder of a negotiable instrument that, when issued or negotiated to the holder, does not bear such apparent evidence of forgery or alteration, or is not otherwise so irregular or incomplete as to call into question its authenticity. And the holder in due course must take the instrument for value in good faith and without notice of certain disqualifying conditions. So the holder in due course has this instrument, and there's nothing on the face of the instrument, on the back of the instrument, through endorsements or notations, that gives that holder any indication that there's a forgery, that it's been altered in any way, or anything that would call into question its authenticity. If you qualify under that definition, you're considered a holder in due course. The question is asking for a person to be a holder in due course of a promissory note. First, the answer A says the note must be payable in U.S. currency to the holder. A negotiable note may be payable in foreign money. So even though the Uniform Commercial Code is a U.S. law, a U.S. statutory law, set of laws actually, it does not require that only U.S. currency can be used. Answer B says the holder must be the payee of the note. And the holder may be, but is not required to be, a maker, payee, drawer, drawee, or endorser. And then answer D says all prior holders must have been holders in due course. And that's incorrect, because a person who acquires an instrument from a holder may be a holder in due course. They may qualify and have greater rights than the holder before them, because again, they have taken the instrument when issued or negotiated, and that instrument does not bear any evidence of forgery, alteration, irregularity, looks at as if it's incomplete, or anything to call into question its authenticity. So therefore, answer C is the correct answer, because when the holder in due course takes the instrument for value in good faith and without notice of certain disqualifying conditions, and the disqualifying conditions could be that the instrument is overdue, it has been dishonored. So overdue would be the date. Dishonored, such as if you write a check and the check has bounced, and they'll note that on there, the check is not good. That means it's been dishonored. Is part of a series of instruments, one of which is uncured default with respect to payments. So there are multiple instruments involved, and one is already in default, and you have knowledge of that. It contains an unauthorized signature, or it has been altered. Is subject to a claim of a property or possessory right, or is subject to any claim in recoupment. So any of those indications are considered certain disqualifying conditions. So therefore, answer C says the note must be negotiable. With holder in due course requirements, remember the holder must take the instrument for value in good faith and without notice of certain disqualifying conditions. And as we said earlier, one of the disqualifying conditions is if the instrument is overdue. And in this case, the question is asking, a purchaser of a negotiable instrument payable on demand would least likely be a holder in due course if at the time of the purchase the instrument is A, purchased at a discount. If we look at the disqualifying conditions, it doesn't have that involved. B, collateral for a loan. Again, that's not one of the disqualifying conditions. C, payable to bearer on demand. Not one of them. But D, if it's overdue by 3 weeks, one of the first disqualifying conditions is if the instrument is overdue. And therefore, that's a disqualifying condition, so you cannot take the instrument as a holder in due course because you didn't take it in good faith. It should automatically tell you if the instrument is overdue that there's some issue with its ability to be negotiated, transferred, or endorsed. Problem 39 is also dealing with holder in due course requirements, and the question states, Cynthia purchased a machine from VCR Inc. for use in her home. She gave a small down payment and executed a promissory note for the balance. VCR negotiated the note to the Finley Company, which gave value acted in good faith, and had no notice of any defense against or claim to the note. Subsequently, Cynthia was able to assert a defense of failure of consideration against VCR if the note did not contain the notice required by the FTC, which is the Federal Trade Commission, and then they give you 4 options. Remember that subsequent holders of a negotiable instrument issued by a consumer for the purchase of goods are given notice of defenses by a statement required to be printed on all commercial paper to which this rule applies. So on that promissory note, there should have been a statement that was required, and it was not. And so the question is asking which of these items would be applicable. So failure to include the notice is illegal as an unfair trade practice, but it has the effect of freeing a holder in due course from personal defenses. Accordingly, the omission would allow Finley to prevail against Cynthia absent any real defenses. So answer A says Finley is not treated as a holder in due course. It is incorrect because the notice would have precluded Finley from being treated as a holder in due course. Answer B states Finley cannot recover from VCR. And that answer is incorrect because a holder may recover from an endorser if the maker dishonors the note. So again, Cynthia is the maker, VCR is the endorser. And answer D states VCR will prevail against Cynthia. And that's incorrect because the facts state that Cynthia has a defense against VCR. So that's really, the facts have already answered that question. So the correct answer is C, Finley will prevail against Cynthia. And again, because they're a subsequent holder of the negotiable instrument and the statement was not involved or was not included. Okay, that concludes our problems for negotiable instruments, also known as commercial paper. And it is my advice that you read through both sections of the module, that you look at the 2, I think one's a song and one's maybe a poem, can't remember, a video explaining these 2. Go through these problems before you take the quiz. And the legal analysis number 1 problem is on negotiable instruments specifically. It does not involve secured transactions. So remember to budget your time wisely. This is a very busy module.